Okay, so it's 12 o'clock. I'm going to officially kick things off. For those of you who don't know me, my name is Amy Thomas. I'm the president of the East Hanson District's Chamber of Commerce, and I would like to thank all of our registrants today for joining in on our COVID webinar series. So the subject today is return to work and COVID-19, which is very timely because the government has opened things up and allowed employers to bring employees back. And I know that there are a lot of questions around how to facilitate that and what that looks like. So we have our expert today joining us, Jennifer Weston of Barteaux Labor and Employment Lawyers. So they are unique in that they are a labor and employment boutique, which means that is the only area of law that they specialize in. So I know that some of you have submitted questions in advance and we will go through those, but if any questions come up based on the conversation, please don't hesitate to reach out. At the bottom of your screen, you'll see there's a chat feature, so you can submit any questions that you may have through there, or you can put your hand up and we're able to unmute your mic just if you want to speak. So without any further ado, I'm going to pass everything over to Jennifer.
Thank you, Amy. I'm really excited to be here. I really appreciate the opportunity to speak with your members on this. So as Amy said, my name is Jennifer Weston and I work at Barteaux Lawyers in Halifax. If you haven't heard of us before, we are Atlantic Canada's only employment and labor law boutique firm. So what this means is that we've developed a deep subject matter knowledge that employers rely on for day-to-day working advice, workplace investigations, and for representation during negotiations, hearings, trials, and appeals. Our clients range from small local businesses to multinational conglomerates, and they span the private and public sector. Our clients are primarily located in Atlantic Canada, but our partnerships through the Employment Law Allowance allow us to give accurate advice on client operations throughout Canada and the world. So when we're working with our clients, our goal is to come up with fast, sensible, and sustainable solutions to workplace issues. And that's what I'm going to try and do with you here today. So governments are starting to lift restrictions, but I don't think anyone would deny that we're all still working in this crazy, unpredictable environment. And the employment questions that you're dealing with today are likely looking different from the norm. So today I want to help you start to prepare for that so that you are ready as issues come up to make decisions quickly and to make informed decisions. The Chamber, as Amy said, sent out a call for questions in advance, and I am really happy with the quality of the questions that came in because it shows that you already are engaging with these issues, and that's so important and my main piece of advice. So I'm going to address each of the questions that we received in advance directly, and I'm hoping in this way we can all learn from what the other businesses in our area are grappling with. If you have more questions as we go through, please type them in the chat box, and we're going to try to get to as many as we can at the end. If I don't have a chance to answer your question, don't worry. My contact information will be provided to you. You can reach out to me at any time, and this is what we do. We're here to help you. So today, I'm going to take a minute and share my screen with you because I do have a PowerPoint. I practiced this. There we go. Amy, can you confirm that that's working?
Yep, all good on our end.
Okay, great. So today, the topics that we're going to cover, which are your questions were really on point of what I wanted to talk about. So they include managing the recall process. So this is how to make decisions about who you're bringing back to the workplace and when you're bringing them back. We're going to talk about how to respond to employee reluctance to return to work. So we'll look at different reasons for this, like it may be an employee who's lacking in childcare options, there may be financial reasons, or it may be fear. The third topic that we're going to get into is keeping the workplace safe. And this is where we're going to talk about what to do if one of your employees has a cough. And I don't know if anyone else is walking around as terrified as I am about coughing in public right now, but it's the taboo thing to do right now. And we need to know how we're going to address that in our workplace and make sure that we're keeping everyone safe. So we'll talk about that today too. Let's jump right in. On this topic, managing the recall process, I've grouped together 2 questions that we received. One is about obligations to rehire staff, and another is about making changes in the workplace that will affect your employees' conditions of work. So the question that we received was, is any employer obligated to rehire someone who was laid off due to COVID-19? And the answer to that question is probably not. But there are limitations. So limitations to your decision not to rehire someone who is laid off will mainly come from 2 sources. That would be the collective agreement or employment contract. If there's one in place that addresses the recall process, then you would have to follow whatever was in that agreement. And the second limitation to your ability not to rehire someone is human rights obligations. So that is an obligation not to make recall decision that is discriminatory in nature. So the best way that you can avoid claims that you made your decisions inappropriately is to create a recall plan where you establish objective factors to guide your decision making. These factors must not be contrary to anything in the employment contract or collective agreement. And then in order to make sure you're avoiding claims of discrimination, you need to ensure that you're following the factors consistently. So these are some objective factors that I've come up with as examples, but it's not a limited list. It's going to depend on what your particular business is. But the important thing for our purposes today is that you're making it clear, you're making a record of what the factors were and how you were making these assessments, so that you don't have, if somebody's claiming that you did it in a discriminatory way later, you can say, no, look, here's the record. We applied these factors across the board. Those factors can be things like the skill and ability of the employee in the context of your business needs, how you've prioritized them for what you need today with your reopening. It can also be on the adaptability and versatility of your employees, their ability to meet maybe the change in your schedules, their seniority. That's often a deciding factor, particularly if you do have contractual or collective agreement to follow. You can make a decision not to bring someone back who hasn't been very productive in the event that you want to bring your most productive employees back first. But you need to be careful, again, that you can back up that decision. So there should be some, hopefully, if you're going to make this decision, some performance reviews that show that that employee has been coached several times and they don't have performance that's comparable to the person you're choosing to bring back over them. And of course, the cost of an employee not being recalled in Nova Scotia, you're going to have a higher cost of terminating someone if they've been working with you longer. Just moving to the next slide here. So these are the decisions, the factors that you want to avoid when you're making this decision. So because they may be perceived as discriminatory, even if there was no intention for them to be discriminatory, they may be perceived that way. And with all that's going on in our society right now, that discriminatory decisions, people are particularly on alert for them and more likely to speak up about them. So I don't know that it would normally be worth the risk. So if you're making a decision to not bring an employee back based on their attendance record, there is a risk that that employee has a lower than average attendance record for reasons related to a disability. And that would put you in the zone of defending a possible human rights complaint. So I would avoid using attendance records as one of your factors, decision-making factors. Another thing that you want to avoid doing is making assessments of your employees' potential susceptibility to COVID-19. This could be seen as discriminatory under human rights legislation as a bias against employees who are over 60 years of age. And the same thing for their medical conditions. If you know an employee has diabetes, so you're making the decision that it's too risky for them to come back to work, and you're going to bring your young, healthy, able-bodied people back first, that could be considered a discriminatory decision. Now, you may end up having conversations with those individuals if they're expressing concerns to you, but where you're not their medical professional, it's jumping the gun to make those decisions for them. Ethnicity is another one that may come up if you're saying, you know, this person has a family, they're an immigrant, and I know their family travels a lot, and that makes me nervous that they might be contacting people who are traveling quite often. That could be that one could end up with a human rights complaint. So you want to be careful of that. So looking at the second question that we got in here, it was, do we have to offer the same job, same shift, same hours as before? Or can we offer what we have available, i.e. day shift instead of night shift? If you are going to make these changes, can your employees refuse them? And if they refuse them, is there somewhere that we need to report somewhere? And are they able to be terminated or moved to the end of the call list? So if you have a collective agreement in place, there are almost always provisions that outline the steps that must be taken in a callback situation. Everyone that I've looked at so far, my advice has been, yes, you have to follow those steps. Even though you may not have anticipated COVID-19 in 2020 specifically, if you want to make changes, you're going to have to work together with the union on maybe you can come up with a letter of agreement given the current climate. If you're in a non-unionized environment, there is still some risk here. Employees have contracted with you for a particular type of work, rate of pay, whatever it is. And if the job changes significantly from what they signed up for, that can possibly be considered constructive dismissal. And with constructive dismissal, if they decide to pursue this through the courts, you may be on the hook to pay them reasonable notice as if you had terminated their position. So there are ways that this can be mitigated. So what's important for employers to remember right now is that you are doing the best you can. These are not ideal times, and you don't need to have a perfect solution. You need to make reasonable efforts. So if your business needs are changing in ways that you need your employees to adjust with them, the best thing to do is communicate. Communicate, get your employees on board. If they understand the reason behind the changes, people more often than not are cooperative. So You can also consider your options to reduce the likelihood of a successful claim. And that, again, involves seeking the employee's agreement to the changes. It could also be limiting the period of time for the change. So if you give them upfront a clear end date, that I understand that this is not ideal and our goal is to get back to normal at a certain point. So we are going to review this at the end of summer. Make these explanations in writing as well, and have your employees sign off on them. If the employees won't sign, and you haven't already, it might be time to start calling your lawyer and just making sure that you have all your bases covered. So a labor and employment lawyer can help you figure out how to move forward so that your business needs are getting met. And I want to say the note about communicating and putting things in writing applies also to positive changes and benefits that you're making in the workplace right now, because many employers have been giving employees paid time off at home. They're allowing flexible working hours that they've never allowed before. They're giving employees hero pay. So these benefits should all be put into writing along with your intention behind them. And it should be clear in that written document that they're not meant to be permanent changes to the position. And this is something that's going to save you regret later on down the road. So common adjustments that we see in the workplace can include remote work, team shifts, work sharing, change of hours, reduced hours or compensation. And yeah, so this slide is basically talking about what I was just discussing and saying, just be careful when you're doing it, and try and get your employees on board and write everything down.
So Jen, I'm just gonna jump in. I have a question here just for clarification. So
Sure.
when you're saying to put all of this stuff in writing, how should they do that? Should it be an email to individual employees, or should it be, if we're talking about positive changes that the employer is making, could it be one to all employees or a policy? What is your recommendation there?
If it's going to affect all of your employees in the same way, then it is fine to do it in a memo and send it out to everyone. But we've typically put it in the letter of recall. If your employees have been laid off, we'll give them a letter before they come back to work that says, these are the changes you can expect. These are the measures we're putting in place to protect you and that we're going to be requiring you to follow. You're expected to return to work on this date. Does that answer your question?
Yes, it does. Thank you.
Okay. So this is my next question. If a person does not have to come back to work, does the employer have to hold their spot open? If so, for how long? So this question is a bit more challenging to answer. This is going to depend on the reason why the person has not come back to work. So it's very important during these times to keep up regular two-way communication with your employees and to do your base level of due diligence in order to understand exactly what their concerns are with going back to work. Once you understand the reason for their reluctance, you're going to be better able to plan coverage for your workplace needs and what you need to do going forward, how long their time off might end up being. So there are several reasons that people are hesitating to return to work right now. Some that we've identified are just a fear of COVID-19 in the workplace. So if you have a production facility where people are standing kind of shoulder to shoulder and there's really no way that they can think that you've distanced, or they don't feel that you've distanced properly to keep them safe. They may be afraid that going to the workplace is just too much of a risk. There's too much exposure at that particular workplace. Other reasons could be that they're cautious due to their age, due to a medical condition that they have, or maybe a medical condition that their spouse has that they don't want to bring home with them, or it could be family obligations like childcare. At this time, there's also people who are experiencing just a general fear of leaving home due to COVID-19. We've seen a huge increase in mental health issues lately. If somebody had already had a mood disorder or an anxiety disorder, it may have become an even larger problem right now that is just affecting their ability to work. And then some people are talking about financial disincentives. So this is going to come up if your employee's income is relatively equal or less than the monthly Canada Emergency Response Benefit. Employees may get it in their head that it's not worth it to go back. They can just collect the CERB. So I'm going to go through each of these examples in order. So fear of COVID-19 in the workplace. Employees do have a right to refuse work where they have a reasonable grounds to believe that the work is likely to endanger their health, safety, or the health and safety of another person. So if somebody's refusing to go to work because they're saying it's not safe, you need to engage with that employee. And it's going to be treated the same way that any other right to refuse, any other work refusal would be treated under occupational health and safety legislation. There's no change to the normal process in this. So you can look up the normal process online and you just follow the same thing. The first step is engaging with your employee. What is the source of your concern exactly? Involve your joint occupational health and safety representative or committee if you have one, and look at ways to try to mitigate the risk that they are concerned about. A lot of times it may be a heightened risk of something that you don't really see it, but if it's something you can change easily, that's usually the fastest and cheapest way to deal with these things. If the employee does not feel that you've adequately addressed the risk, they can make a complaint to the Joint Occupational Health and Safety Committee or to the Occupational Health and Safety Division of Nova Scotia Labour and Advanced Education. If they do this, an OHS officer will come investigate. And you must continue to pay your employee during the work refusal. But you can reassign them to other work. So I don't know if it would be appropriate in your workplace. They may be able to work from home or somewhere else, or you may have been able to find a temporary solution for them while this is being investigated. Typically, OHS does mobilize quite quickly for this investigation, sometimes even day of. I'm not sure how COVID-19 complaints have been affecting their ability to respond promptly. I haven't heard anything on this yet myself. If you have any experience with that, let me know. But normally they don't take a long time to come do those investigations. And if you look online, as I said, the Workers' Compensation Board of Nova Scotia has resources on COVID-19 prevention and working safely based on your industry. So if you're following along with these guidelines and with any measures that have been required by the Health Protection Act, public health directors, and the emergency management orders, it's likely that the investigation is going to find that you're taking reasonable steps. Again, we're not looking for a complete no risk of COVID environment here. We're just looking that you're taking the reasonable steps that are recommended by government. If the concern is a nature that's more personal to that specific employee, the employer may have a duty to accommodate. So even if the investigation's clear, they're saying, no, this is the normal risk that everyone else is facing and that we've decided as a society is an acceptable risk. That person may still have a physical or mental disability that makes it justified for them. They might be a member of an at-risk group, or they may have a family responsibility, and that's conflicting with this. So we're seeing this a lot with daycares right now. They're down by, I think they're down by 50%. That's going to leave a lot of parents without childcare, and that will impact their ability to return to work. So family status is a characteristic that's protected under human rights law. The employee must show you that that accommodation is necessary, including for family status and alternate child care. Typically, the employee, you can ask them for documentation to show the efforts that they've made to find child care and outlining the reasons why they haven't been able to find appropriate health care. Or if it's a physical mental disability, we typically ask for documentation from their doctor saying they have a disability and it is going to affect their ability to work in this way. For example, they can't do this and this and this, which I understand is part of their job. Right now, we're asking employers to be as flexible as possible, not to put unnecessary burden on your employees. That is going to be difficult for them to fulfill. And you can kind of take note of their situation if you are aware that their daycare is not open because no daycare in your town is open. You don't need every employee to go get a letter from the daycare saying that it's closed. And you don't want to force someone who's saying they have a health issue to come into work until they can get medical documentation saying that they don't. Though I'm finding personally that the doctors are being quite prompt since they've switched to telephone appointments. So just be aware with that, use reason, but whatever it is, once they've established their need, write it down, keep it in a file. That's always my advice. Write down, document that they requested this accommodation on this date, and these are the reasons that they told you. Once the employee establishes that they do need an accommodation, human rights accommodations are required up to the point of undue hardship. So reasonable accommodations are acceptable. You don't have to give the employee exactly what they're asking for. For example, you can require an employee to work from home if the type of work would allow for that. You may need to assist them to get set up. And that's a big question employers are facing right now. And the answer is it depends. You can adjust employees. You can adjust their hours of work. We've had conversations with that around travel time. So if somebody's taking public transportation to work, can you adjust their hours so that they might be traveling at a time that the bus system is less populated, so there's less risk to them for that travel period. Be creative, be flexible wherever you can. We're all in this together. If the accommodation is going to end up being a leave of absence, you don't need to pay the employee unless there's legislation, contract, or policy in place that requires it. But you do need to hold their position for them. So this will go back to answer the original question of how long do you need to hold their position for them. It's probably going to be for a long time. And if you're considering a refusal of this accommodation request, or if you're considering that you're not going to hold that employee's position any longer, it is prudent to call your labor and employment lawyer to discuss what undue hardship would look for you, and if you've met that level in this situation. So I do recommend calling a lawyer on that one.
And just to clarify what you're saying, undue hardship. So you have to keep it open, you have to accommodate, unless keeping the position open would amount to undue hardship for the employer.
Right.
Okay. I wasn't sure if everyone knew about that, so I just thought I would jump in.
Yeah. So that's, yeah, like I said, so it's the first step is the employee to establish that they have a need for it and to give you their reasons. And then you need to give the employee a clear response. And that should be put in writing as well, that you are deciding to provide them with an accommodation, or you're deciding not to provide them with an accommodation because your business is not able to meet that. And that's where I'm saying use every effort to be creative and flexible so that you can meet it. And if you can't meet it, that's when you should call your lawyer to make sure that you've done everything that you can do under human rights law. If your employees are experiencing just kind of generalized, COVID's still out there, I don't want to work, I'm getting paid to be at home, why would I take the risk? I might as well stay home play with my kids and collect the CERB benefit. So if they don't have any documented human rights reason or to stay away from the workplace, and there's nothing that you're doing in your workplace that if you're not going against safety obligations in your workplace, and you've communicated with the employee and you've ruled out all these work safety related issues, you may be able to treat a refusal to return to work as a resignation. This comes with certain cautions. So you want to make sure that you're very clear about that with your employee in writing. You want to advise them of the expectation to return to work by a certain recall date. And you need to put in writing in the letter that if they fail to return to work, they will be considered to have resigned and will have no further entitlement from you. You want to warn them that entitlement to government benefits may be affected by their decision not to return to work. And again, you want to give them that opportunity to respond to you, and you want to listen to their concerns. You want to educate them on the safety measures that you've put in place and explore other options. So you want to be doubly sure that they're not going to come up later and say that they needed a human rights accommodation. If the employee is stating that they do not wish to resign and they want to take unpaid leave, take the time to explore if there's appropriate leave that they could take. It's not really the time to draw hard lines in the sand here, because there are risks to deem resignations. Courts have held that resignation must be clear and unequivocal. So if the employee starts insisting that they do not want to resign and they're just looking to be on unpaid leave until COVID is over, it might be a better option to either look at if there's some unpaid leave that might be available to them, or to just go through the steps to terminate their employment. In this case, you might want to consult with a labor and employment lawyer. You may or may not have just cause to terminate, and that's going to depend on the situation. And so this is my last question, keeping the workplace safe. This person wrote to us and said, my employees are back to work. If one of them gets a sore throat, they need to stay home. For how long? If they have to quarantine, can they apply for any funding? Am I responsible to pay them? What are my rules around this? I can't have people coming to work that feel sick for everyone's safety. I am telling them to stay home. What does that look like? And I think that is a very good question to be asking yourself right now. And in the best case scenario, what it looks like is good planning. If you have not already, you should be preparing a COVID-19 workplace prevention plan. For some industries, this is required by law, but it is the best practice for everyone. It's also likely that you'll need to prepare what I was mentioning before to Amy's question, to prepare letters of recall with the information that your employees are going to need about returning to work and the new safety measures. So this plan, this COVID-19 workplace prevention plan, will set out your plan to keep the workplace safe. And it's going to include the measures you're taking in the office, like social distancing, as well as the process and reporting obligations for employees who have suspected or confirmed cases of COVID-19, or employees who have traveled or been exposed in some other manner. So when you're making your plan, there are so many resources out there right now to help you. The first step is identifying which symptoms are cause for concern. So your right to require your employee to stay at home is based around your legal obligations to keep your workplace safe for your other employees and for your clients. But it's an obligation that always has to be balanced against the rights of employees not to be discriminated against for a physical disability, their rights to privacy. And so it is a balancing act. And this is why it's important that you keep your policy up to date and that you're identifying the risk factors and the return to work plans based on current information from public health authorities. So I'm not going to answer how long they should stay home for, because I want you to be checking with your public health authorities on a regular basis and adjusting your policy as necessary. Recommendations are changing so frequently right now. So someone, a committee or a person should be responsible for making sure that they're watching these things. At this time, looking through, it's reasonable to require an employee not to attend at work if they're exhibiting a fever, a new or worsened cough, shortness of breath, difficulty breathing. And then you're going to be looking at directing the employee to seek medical attention to confirm whether a test for COVID-19 is appropriate. You may want to have in that plan that an employee may return to work when they're cleared to do so by a medical practitioner. So saying to the employee, you have symptoms that are consistent with COVID-19. If you've been recommended after you call 811 to do the test, then we're going to need a clearance by a medical practitioner before you come back into the office. At this point in time, that's reasonable. As I said, that might change as we go along. If an employee has a probable or confirmed case of COVID-19, it's the same thing. They should be at home until they're cleared to return to work by a medical practitioner. If someone has a household member or someone that they have close, regular contact with who have been diagnosed with COVID-19, the recommendation right now is for people who have that close contact to isolate for 14 days. And so that's a self-assessment, and if an employee is reporting that to you, you should be accepting that. A big change from normal operating procedures is that you may have already probably heard about on the news, is that employers are not allowed to ask their employees for a doctor note if they're staying home because of COVID symptoms or because they are required to self-isolate. And this is one of the reasons right now that public health is saying you need to self-isolate if you've been in contact.
Jennifer, I'm not sure if
Close
you
contact
can...
an employee with COVID-19 within 3 days of onset of symptoms. So basically, it's if public health has recommended that they self-isolate. So there is no reporting requirement right now to public health from the employer. The employer should tell your employees to call 811. Public health will then get in touch with your employee, and public health will reach out to you if they think that there's cause for concern and that you should be closing your business. So You don't automatically have to close your business if one of your employees goes home with suspected symptoms. If there is a concern, public health will be contacting you. Your policy, your workplace prevention plan should be addressing what documentation you're going to require before the employee returns to work, and so should that should be reinforced at the discussion when the employee leaves. So it's good to know that ahead of time. It might be sufficient to just say, send me an email in writing saying that you're clear of symptoms. In other situations, if they have a confirmed case of COVID-19, you might say, I'm going to need a note from your medical practitioner that confirms you're clear to return. Do you have to pay them? No, employers are not required to pay employees for the time off work. But if employees are experiencing financial stress from being off work, they might be less likely to self-report their symptoms, or they might be tempted to downplay their symptoms because they don't want to lose out on the pay. You need to just be aware if there's tension around this in your workplace so that you can manage it, because you don't want people hiding symptoms and then bringing them to work. If you have your prevention plan in place and you have your instructions for employees and what they have to do clearly defined, you can discipline someone based on not following these new health measures. If you have sick leave benefits in place, encourage your employees to use them and see what you can do to help them if there's financial concerns there. Look at if it's possible to advance sick days in certain cases, or if they can use vacation days. And do whatever you can to help your employees identify and understand the government benefits that might be available to assist them financially if they're off work due to COVID-19. There's a lot of programs out there. It's starting to get confusing. They're changing all the time. And if your employee is sick or stressed or scared, that's something that you can really do to kind of help them through that process. So that's all I have prepared. That's all the questions that we got in. And it's 12:43 now, so I think we should have time for a few more questions if anyone has anything.
So I have a few comments and follow-up questions. Just when you're talking about the COVID plan, when I get off this webinar, I will check with our staff, because I know that we have a couple samples, and if they're not on our website already, they will be. Just keep in mind that these are general COVID plans, but at least that way we can help our business owners get some precedents in their hand to use. And another question that I had, when earlier on a slide you were saying if you re-offer the job and the person says no, maybe they're making more on the emergency response benefit, it could be a refusal that may qualify for just cause. So just for those on the call who may not know what just cause is, can you explain the notice period around just cause and how it's different from another termination?
Right. So you're not allowed to terminate someone without just cause without paying them notice or giving them physical notice. So if someone's refusing to come to work, it might be just cause. It might give you that reason to say, if you don't come into work, you will be terminated, and we're not going to pay you notice, and we're not going to pay you benefits. But in order for just cause to work, it is a legal definition, and it's not based on one, not always based on one action, that unless that action is really, really bad. And so that's why I'm saying you need to put the warning in writing. You need to be very clear with them. But we've actually been recommending to a lot of employers to not even get into the just cause question unless you've already told your employee, I'm considering this not just cause, you're not being terminated, you're quitting because you're not coming into work when you're supposed to be coming into work. And again, there are risks there that you need to manage. So if you're going to choose between these strategies, that's the time that you might want to be talking to a lawyer.
Okay, thanks. And one more quick question that I have that you may or may not know the answer to. Are employers allowed to ask employees about symptoms directly, or is it more of a self-assessment where they'll tell the employee, if you're feeling any of these symptoms, don't come to work?
Right, so that's a good question. That question gets into the balance between your employee's right to privacy and your right to protect your workforce. So at this time, you don't need to know exactly what their symptom is, likely, in most workplaces. What you need to know is that they do have some symptoms or they don't. So it is, that's why you need to be keeping abreast of what the symptoms are that public health is telling us to look for. And you need to be sharing those with your employees. So I think I've already noticed in a lot of buildings now, right when you walk in, there's a big placard that says, if you're experiencing any of these symptoms, don't come in the building. And it's the same thing for your employees. You need to tell them, if you are experiencing one or two of these symptoms, you need to tell us. So they don't have to tell you which symptom they're experiencing, but they do have to tell you that they're experiencing symptoms. And then if you're going to have your employees sign off on that, some employers are getting employees to sign, I confirm I'm not experiencing these symptoms. If you're going to start doing documentation like that, you need to be very careful about what you're doing with the documentation, that you're only using it for the particular purpose that it's being collected for, that you're properly disposing of it after a reasonable period of time, that you don't need it anymore, and that you're keeping it in a place that is locked and not accessible to anyone who doesn't need that information.
Okay, thank you. So I see we have a question coming in from Leslie. So Leslie, I'm just going to try to unmute you on my end. I think you're on now if you want to go ahead, or maybe you have to take your mic off.
Hi, can you hear me?
Yes.
Okay. My question is, how do you handle an employee who we really need her to come back full-time right now, but she's collecting the $2,000 a month CERB, but she's only wanting to give us 18 hours a month because she can collect an extra $1,000 on top of that without having to come back full-time?
Right, so I'm getting an echo here, so maybe you can mute your microphone while I give my response. Thanks. That is another kind of variation of what we talked about. If the employee is completely refusing to come back because of the financial disincentive versus an employee saying, I'll come back but only part-time because of the financial disincentive. The financial disincentive does not give them a legal leg to stand on if they're going to be refusing work hours. They need to come back and do their work, or they can be disciplined for not coming back to do their work, as you would a normal employee who's not showing up to work for shifts or not showing up on time. My caution is that you have to be extra careful these days to ask questions. Why is it really just the financial benefit, or is there a human rights related reason? One of the ones that we've talked about here.
Leslie, does that answer your question, or do you have a follow-up on that?
It's a tough one because I know that she's making she's saying that it is a human rights issue, that she now has to be involved with childcare, which is shocking to me because she doesn't have a child. So yeah, so that's my issue, but I guess we just have to tiptoe lightly around that.
I mean, you don't have to tiptoe lightly around it. What I would suggest is actually formalizing it. And that's when you want to the better paper trail you have, the better off you are. So yes, you want to be compassionate and understanding and flexible and creative, but tiptoeing is typically when things go off the rails, because you're going to have other employees saying, well, why does she get to stay home and I don't get to stay home. You know, I have 2 kids. She doesn't have any kids. So you need to make very clear your expectations. The expectations are to return to work. If there's a reason, a human rights reason that you can't return to work, you need to tell us what it is and give us supporting information about that so that we can make an assessment on whether we are going to agree to your accommodation or not. And then you can give her an answer. No, we don't believe that this meets any human rights need, and so we are not going to be accommodating this.
Thank you.
Okay, does anyone else have any questions? If you do, you can raise your hand or you can submit your question through the chat feature. Okay, I don't see anything else coming in. So I'll wrap things up. Just to summarize, you can expect us to, we've recorded this webinar today and it's going to be going in the resources section on our website for COVID-19. So you can rewatch any and all webinars that we put on. As well, we're going to continue to provide resources. So we do already have resources on our website around COVID-19 and employment. And if we don't have a draft workplace policy in place, we'll get one up to you as soon as we can. This is a unique situation because it's in flux. So things are always changing, expectations and standards are always changing. But as soon as that information becomes available to us, we will share it with you, our members. So I do want to thank everyone for their engagement and participation in this webinar today. We've had some great discussion. I know I personally have learned a lot from this, and it seems that there's a lot that we all need to be aware of. And on behalf of the Chamber, Jennifer Weston, I would like to thank you very much for taking the time today to put this presentation together and give us timely, factual information that can help everyone get back up and running. So,
well, thank you very much. It was great to have this time with you, and I know these are top of everyone's mind right now, so I'm happy to help where I can.
So yes, thank you very much. And I see Jennifer's information is up on the screen. So if anyone has any other follow-up questions, they can contact her directly, or if they're looking for her information after this webinar, you can just contact the Chamber and we'll pass the information along. So yes, thank you very much. And I hope everyone enjoys the rest of their Friday afternoon.
Thank you.